The Trump administration went on the offensive in federal court yesterday, but with 300 cases, who can keep track? I am here to help you cut through some of the noise and stay up to date. Happy Tuesday, everybody. I'm Brian, and this is the morning report for August 5th, 2025. Now, yesterday generally was a bit slow, but it was a busy day at the Department of Justice. They seem to be filing a bit more on the offensive yesterday, so let's get into it. You ready? Okay. First, we have a surreply in AIDS Vaccine Advocacy Coalition v. State Department. Now, a surreply is a reply to a motion, or a response to a reply brief to a motion, whatever. This is why people hate lawyers. Anyway, this case is about foreign aid funds that Congress already appropriated, but haven't been dispersed. So under the law, those funds have to be awarded through a competitive grant process before the fiscal year deadline in September. But according to an anonymous declaration from a USAID contracting officer, there is a problem. Nearly the entire USAID staff has been laid off. Without them, there's no way to evaluate proposals, finalize the award, so even though the law requires the government to get that money out the door, there's no one there to do it. Now, the government responded with this surreply. And by the way, I am not making fun of the government here. I'm making fun of all lawyers, including myself, for using words like surreply. Whatever. So the government responded with this surreply, downplaying the anonymous affidavit from the guy who works at USAID. They argue that this employee does not speak for the agency and that only leadership, the people Trump put in charge, can say what's really going on. They also say that under the Supreme Court's CASA ruling, the court can't order broad relief, only relief that directly benefits the plaintiffs in the case. And the plaintiffs, by asking the state to restart this process, would or could also be giving grants to organizations that aren't plaintiffs in this case. The thing is, that's not exactly what CASA says. The decision does limit relief to what's necessary to help the plaintiffs, but it also makes clear that courts can extend relief to others if that's the only way to fully protect the plaintiff's rights. Then again, CASA is a really confusing case. I should probably not be telling you what it says until we find out from the courts a little bit further. Now, there is a second case, Global Health Council v. Trump. It is basically the exact same situation. It seems like the lawyers here may be using the copy and paste button a little bit, because they filed a surreply in this case as well. It's exactly the same lawyers as in the first case, and basically they're making the exact same argument, except this time they didn't bother with CASA. So basically they say, don't trust the internal people who are providing anonymous reports from inside the building, only listen to us, the politically appointed people in charge. The problem is, of course, that the facts as described by the anonymous reports have been widely reported by almost every news agency in the world. Most of the staff of USAID was laid off. And we have seen that everyone in charge who doesn't say everything is great gets very publicly fired. So I'm going to leave that one to you, maybe a jury. Either way, we all learned what the word surreply means today, so that's fun. Okay, so that's where we are with those two cases. Now, we're going to talk about US v. Russell. In this case, the US government is actually suing the US District Court for the District of Maryland over standing orders that automatically block immigration removals whenever a habeas corpus petition is filed. In a new filing yesterday, the government supported its motion for a preliminary injunction and opposed the court's motion to dismiss, saying it exceeds judicial authority and violates federal procedures. Now, the defendants, including the chief judge, argue the orders are administrative stays and they are well within the court's discretion. The government wants to stop the enforcement of the orders and resolve the issue through a facial challenge. I will be honest, this case is very confusing. It includes a lot of big, conflicting, old legal concepts. I am not totally sure that I understand all of them, but I will call your attention to the use of preliminary injunctions by the government here. Remember how hard they've been fighting the use of preliminary injunctions when they are against them. This is different from CASA, though, because the equitable relief is more narrow. That said, I would not want to take on a chief judge in court. No, thank you. Remember that this case exists. It's a big case where the executive branch has sued the judicial branch. It's going to have consequences, so keep your eye on it. Okay, this is our last case for today. This is Newsom v. Trump. In this case, California sued the federal government to block President Trump's deployment of National Guard troops in Los Angeles. And there were two filings in this case. One is substantive, and I'll do that one real fast. The other is procedural, so it's a little more boring, but it brings up something really fascinating that I want to draw your attention to. First, we'll do the substantive one. So we have a supplemental brief from the government, just some back and forth discussing the arguments. And here the federal government opposes California's attempt to block the deployment of National Guard troops in California in Los Angeles, arguing that the case should be dismissed for 5 reasons. 1. California can't sue under the Posse Comitatus Act, which is basically about military use on civilians. There's more, but that's the short answer. But the federal government says that that the Posse Comitatus Act is a criminal statute. This is a civil case, so the state can't use it here. Second is that the president lawfully used the National Guard under a statute that allows it. The third argument is that the troops are protecting federal property. They're not acting as local law enforcement. Fourth, they say there's no legal or factual basis for a court order. And fifth, the government argues that the president cannot be personally sued or restrained by the court. Now, that last one is sort of a standard argument. There are ways that this gets worked around. The government usually throws it in anyway. I wouldn't get hung up on that one. Okay, the second filing is the procedural one, but it's hiding something really interesting. So this is a motion to file under seal, which means the government is asking the court to keep certain documents away from the public. Because, among other reasons, quote, the military deployment in California has been subject to significant public scrutiny, and, quote, the public disclosure of the identities of the individuals involved in the email threads and the nature of the discussions could subject the individuals involved to annoyance and embarrassment or potentially even threats of violence, and at a minimum, chill future government deliberations about such topics, end quote. Now, the court does not like answering what are called political questions, questions that tend to be debated by election officials and also tend to help decide who someone votes for. But if this case gets framed as whether or not we need to be protecting the identities of people making unpopular decisions in government, or as they said, chilling future government deliberations on certain topics by letting the public know what's really going on, that could be another question. Similarly, I know right now it may seem like the debate over whether ICE can hide their faces might seem kind of new, but there's been a debate over law enforcement properly identifying themselves for decades, if not longer. And lots of people have campaigned on this issue. We got body cameras, badges that identify officers' names. We've all seen TV shows where the police have to let the person know they're police before they kick the door down. So the court may not want to make a decision about this if they think it should be made by people who get elected. And I don't know if California will push back on this or not. If they do, I would keep an eye on it and see if it develops into something. This could have really big implications if it's argued properly. Okay, that is the Tuesday morning report on the past day in federal courts. Please follow me for more information about the law and government, and please watch these videos and comment. Tell me what you think. Which parts of these cases are interesting? How do you think the court should decide on some of these? Share these with somebody who might find them interesting, and just keep watching and I will keep going. Thanks everybody, and have a great Tuesday.